Okay, we are now live and on the record for Monday morning, April 11, 2022, 11 a.m. court docket. And let me see. Okay, do you, Ms. Cedillo, have a quick announcement?
I don't believe it'll be a quick announcement, Judge, no.
Okay, so then I'm going to go ahead and call P0057-22-9 Jennifer Basulto versus Danon Jonathan Basaldua.
Yes, Your Honor. Good morning. Ana Cedillo on behalf of Ms. Basaldua. I represent the applicant on this matter. We are present and ready, Judge. There was one issue that was pending before the court the last time. Well, it was not pending. I apologize. I had just been retained on this case, became aware that there was an issue on the same issue that we've had in the previous case, Judge, and that's with regards to Mr. Williams representing his client, Judge. We don't believe that he can represent. We filed a motion to disqualify him because he's previously represented my client. So because that motion had not been on file, at the last hearing, the court reset it, gave me time to file that motion, Judge.
Okay, did you file an order setting hearing with that?
I believe I did, Your Honor, but I can't confirm that right now.
Okay,
I don't think so, Your Honor, but because the docket sheet shows that it's not set, although it does show that one was filed, although I was not served a copy of the motion to disqualify, nor was my client. I did file a response this morning in anticipation of, I haven't seen what the motion is, but I said, well, here's my best shot at a response since I don't have the motion.
Judge, and I apologize, Mr. Williams may be accurate. Judge, we typically include through the e-file system, but if Mr. Williams had not been attorney of record, he would not have been notified, Your Honor. I apologize for that.
Okay, well, I mean, but did you preserve any type of waiving of any rights, Mr. Williams? Because if you filed a response to a motion that you had never seen.
I did note in the motion that I objected to not being served with the motion, indicated that I had not seen it, but indicated that in an abundance of caution, I would at least take a shot in the dark file a response.
Okay, Mr. Veta, do you see the order setting? Okay, do you see the order setting hearing on the motion to disqualify?
No, Judge, the motion was filed on the 6th. There was not an order setting hearing or an order granting or denying. However, there wasn't an answer, like Mr. Williams said, he did file an answer to, or his response to petitioner's motion.
Okay.
And the court had previously given us notice of today's date with the anticipation that that motion would be on file. We argued that same issue on that date, Your Honor.
Okay, so this is what we're gonna do. That motion to disqualify will be argued in person. File an order setting hearing on it for Ms. Rivera. When can we accommodate them in person?
Judge, we have May the 4th or May the 2nd
Okay, at what time?
at 2 o'clock, Your Honor.
Okay, May 4th at 2 p.m. That'll be, so far, we're still using County Court 4's courtroom. And we're gonna extend the protective order until that time period.
Very good, Your Honor. Your Honor, I do have, there was another issue that we brought up at the last hearing, and I'm hoping that perhaps it could be heard at the same time. I have filed a motion to have the case that was previously in the master court, but is on file in this court, brought up to this court, and also, and because the motion to disqualify me there, the court never entered an order. It did give a preliminary indication that it would disqualify me, gave no reasoning. We requested an order. Ms. Cedillo, the court asked Ms. Cedillo to submit an order. She did. The court didn't enter that order and rejected it, sent it back, and there's no order filed in that case yet. So we're hoping to either, I don't know what the court wants to consider it, a motion to consider, a motion to reconsider, a motion to appeal, whatever, but that court has not yet filed a written order. But it is our understanding that that court intends to disqualify me or to submit an order to that effect.
Judge,
Okay.
and that's correct. The court did give a ruling, as a matter of fact, as to that disqualification. For whatever reason, the court has not signed off on that order, but it's our position that Mr. Williams's right to appeal is not based on the signing of the order, but upon the ruling of the order, and he would not have timely filed that. But nonetheless, Your Honor, I don't mind taking up all the issues on that day.
Okay, so we'll go ahead and do that. If you have to file an order setting hearing, set it for May 4th at 2 o'clock.
Very good. Thank you, Your Honor. Having nothing further before this honorable court, may my client and I be excused.
Yes, everyone's excused on this case.
Thank you,
kindly,
Judge.
Your Honor. Have a great day.
Thank you. Okay, so is everyone here on CL 153115-I? I know Mr. Livesay is on. No. Mr. Salas, are you on this case?
Judge, if I may, yes, he may be a witness, and he's here with me.
Oh, okay. So then he may be a witness? Okay. So what I'm gonna do is go ahead and put him in the waiting room.
Okay,
Okay, let me go ahead and do that. Okay, is anyone going to need the services of an interpreter? Okay, so then I can go ahead and release my interpreter. Ms. Castañeda, you're excused?
Thank you, ma'am.
Yes, ma'am. Okay, let me go ahead and call CL 153115-I, Armando Gamboa et al. Versus Fernando Godino et al. Announcements from the attorneys, please.
good morning, Judge Sergio Garza for defendant Dimas de Leon.
Good morning, Your Honor.
I know it's hard. Okay, Ms. De Ochoa?
Good morning, Your Honor. Sonia De Ochoa for the defendant, Jennifer Vargas.
Good morning, Your Honor. Keith Livesay on behalf of the plaintiffs.
Okay, so, Mr. Garza, is this your motion?
That is correct, Judge.
Okay, do you anticipate this to be long?
I wouldn't think so, no. I don't think it should take more than 10 minutes.
Okay, because Mr. Livesay said that he already mainstreamed his arguments. Okay, go ahead, Mr. Garza, this is your motion, so you may begin.
Okay, Judge. So I'm representing Mr. Dimas de Leon. This case was previously in county court at law number 4. And in that court, in both 2016 and 2017, there were 2 default judgments that were issued against my client, Dimas de Leon. And there were also two default judgment liens predicated on those 2 default judgments that were placed on Mr. de Leon's property, real property. And but the thing is that both default judgments have been set aside, but the liens are still there. And what we're asking the court is that the court remove those liens and order the plaintiffs to sign a release of those liens, because as I said, the judgments upon which those liens are predicated have been set aside. So there is no final judgment against Mr. de Leon in this case, and therefore there shouldn't be any liens on his property.
Okay, Mr. Livesay, do you want to respond?
Yeah, our position is that the orders are ineffective and void because they were entered in past the time permitted on them. And so we don't believe that the liens are still valid. And what we are willing to do, I mean, this came up because of they want to, our understanding is Mr. Dimas de Leon is currently in prison. What we're willing to do is, agree to have the property sold and have the deposit, the excess proceeds put into the registry of the court or some other form of relief so that the sale of the property doesn't go through. But we think that would be the appropriate remedy in this case instead of just a flat out release and letting them pocket the money.
Judge, the fact of the matter is that the default judgment, the judgments have been set aside. They have been vacated. There's already 2 orders vacating both default judgments, and the lien can't stand because it's an invalid lien because there is no more default judgment.
Okay, so I'm looking at the order granting that Judge Garza signed. And in there, he also ordered Mr. De Leon to pay Mr. Livesay $1,000 within 30 days from that date. So are you saying that that order is not valid, Mr. Livesay?
Yeah, I understand there was a severance, and so that the motion, neither the motion nor the order were in the severed clause number, from what I remember.
Okay, well, let me see. Because what I'm seeing here, he signed this back on May 14th, 2018. Were you paid that relief that was ordered, Mr. Livesay?
Yes,
Okay. So you're saying that one is the order that you have an issue with?
yes,
Okay, but they complied with that order and paid you the $1,000.
well, I
And-
mean, that doesn't mean that the order is valid. I mean,
What's
you know,
making it not valid in your
it was
opinion?
if, what is the date on the order as shown by the court?
May 14th, 2018.
Okay, the default judgment was taken in 2016. There's a 30-day window, possibly a 90-day window on entering these orders, and that wasn't satisfied in this case.
Okay, but also then wouldn't you all have filed something right after or argued that it was too late? I'm assuming you made that argument when the judge still set aside the default judgment.
Yes, Your Honor.
Okay, so he still set it aside, is that correct?
Yes,
Okay, and nothing was filed to appeal his order that was signed on May 14, 2018.
no, my clients too can't afford to do that, Your Honor.
Okay. All right, anything else?
No, Your Honor.
Okay,
I promised I would be brief. Was I brief enough?
you were just perfect, yes.
Okay.
Okay, so in reading what okay, I understand your arguments and I understand, and I've read the motion that Mr. Garza filed as well, and I'm reading the orders as it was executed by Judge Fred Garza. And it's nothing was, since he had the discretion at the time to still continue, to still enter an order setting aside that default judgment. And obviously he ruled against any argument that it was not done in a timely manner. So now that that was already signed back in May 14, 2018, and nothing has been filed, nothing has been filed to appeal that decision. And unfortunately, because of perhaps Mr. Livesay's client situation, but nevertheless, it is still a valid order in my opinion, and that'll be my ruling, that it is a valid order, and therefore the court is granting the defendant's emergency motion to remove the default judgment liens. Is there an order to that effect?
Yes, Judge. I filed an order granting along with the motion.
Okay, I'll go ahead and have my court coordinator request that so that it can be sent to my queue.
Okay, Judge.
Okay. Thank you so much, gentlemen and Ms. De Ochoa. And you all have an excellent day today.
Thank you,
Thank you.
Judge.